Hey folks, welcome to today's Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, attorney Andrew Branca for Law of Self-Defense. Today was the 8th day of the trial and the final day of testimony by which Assistant DA Thomas Binger is seeking to have Kyle Rittenhouse convicted and sentenced to life in prison for having shot 3 men, 2 fatally, the night of August 25th, 2020 in Kenosha, Wisconsin, when the city was suffering a tsunami of rioting, looting, and arson following the lawful shooting of a knife-wielding Jacob Blake by Kenosha police officers. And today, the final day of testimony in the trial, was the first time the prosecution had offered any evidence in this case that was arguably inconsistent with Kyle's core legal defense of self-defense, in a case where that legal defense of self-defense must be disproven by the state beyond a reasonable doubt. Worse than the late hour of this final evidence, that evidence came in the form of 2 fuzzy, enhanced photo exhibits admitted in the closing minutes of the trial, under circumstances in which even the state expert responsible for creating the images cannot tell the court that the enhancement process hasn't loaded them with false artifacts not present in the original images. Indeed, that expert who created the enhanced images testified before the jury today that he had personally never bothered to compare the original and enhanced versions of the images side by side to ensure that the enhanced version was a fair and accurate representation of the original. The state's claim is that the offered images demonstrably and incontrovertibly show that Kyle Rittenhouse pointed his rifle threateningly at Joshua Ziminski in the moments before Kyle was murderously pursued by Joseph Rosenbaum. I know you're all wondering, so here's my copy of these purportedly pivotal images that the state claims proves Kyle Rittenhouse guilty of 5 felonies and a misdemeanor gun charge beyond a reasonable doubt. It's worth keeping in mind that other than these images, there is literally zero evidence in this trial that is inconsistent with Kyle's claim of self-defense. So to believe that legal defense disproven beyond a reasonable doubt, these images are all one has on which to base such a belief. Perhaps you see that disproof of self-defense beyond a reasonable doubt in those images. I certainly do not. To believe the state's representation of these images, you would also have to believe that right-handed Kyle suddenly decided to hold that rifle in a left-handed manner, with the buttstock in his left shoulder and the muzzle raised upward. Instead, it's far more likely that the right-handed Kyle was holding the rifle in a right-handed manner, with the buttstock in his right shoulder and the muzzle pointed down, much as he is in this photo from Happier Times. It's also worth noting that these images were pulled from the video footage captured from a drone that the state did not possess until this past Friday, and these enhanced versions of the images were not available until today. That means that for 15 months, the state investigated and prosecuted Kyle Rittenhouse for these many felonies and the gun charge without this purportedly decisive evidence in its possession. And without this purportedly decisive evidence provided by the evidence fairy at the 11th hour, what was the justification for this prosecution? It certainly wasn't the enhanced drone photos that the state did not possess until today. The admission of these images into evidence in the first place was a sketchy proposition from the start, with the defense reasonably objecting for grounds we'll cover in detail in a moment. Indeed, when Assistant DA Jim Krause, leading the lumbering charge on their admission, sees that he might lose that argument, you can fairly smell the flop sweat over the internet. If you've never seen a grown man beg another grown man for a desperately desired favor, you'll see it in the video I'll share here of Assistant DA Krause virtually begging Judge Schroeder to allow these images before the jury. Now, there were other witnesses today, most notably defense use of force expert Dr. John Black, but to my mind, the energy of the day was centered around this pair of fuzzy images that I'm sure the state will use as the foundation for their otherwise House of Cards narrative of guilt in their closing arguments on Monday. So I'll start off today's content by focusing here on these images. Before I do that, I would like to mention our sponsor of today's content, CCW Safe, a provider of legal service memberships. What CCW Safe does is pay its members legal expenses of the members involved in a use of force event, and those expenses start big and get bigger fast. If you've shot someone in self-defense and find yourself charged with murder or manslaughter, it's easy to burn through $200,000 before you even get to trial. So if you don't have that kind of money stuffed in a mattress, it can be helpful to have a partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depends on it, because really, it does. I've looked at all the companies that offer these kinds of services, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can use the discount code LOSD10, LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCWSafe. Okay, so let's dive into these images. But before we do, into the brouhaha around these images and their admission, it's worth taking a moment to discuss what's generally required for photos to be admissible as evidence in court in the first place. Evidence in court generally comes in the form of witnesses possessing direct personal knowledge of whatever it is they intend to testify about. Mary saw the dark-haired man rob the liquor store. She can testify about what she saw, her personal perceptions of that event. Photos and videos, of course, cannot take the witness stand and testify for themselves. They get admitted into evidence when a human being is first brought in to provide an evidentiary foundation for their admission. So if a photo taken of a crime scene is going to be offered into evidence, the person, say, who took the photo, might be brought in to testify in person that the photo being offered into evidence is a fair and accurate representation of the scene it depicts. Without that evidentiary foundation, the photo is likely not admissible as evidence. In this case, we have this unicorn drone video that the evidence fairy dropped off on the prosecution's doorstep this last Friday in the midst of the trial. The prosecution would like you to believe that this drone video shows Kyle Rittenhouse pointing his rifle at Joshua Ziminski and thus provoking the attack of Joseph Rosenbaum. As I've written elsewhere, a purported provocative act of this kind by Kyle opens an avenue of attack on Kyle's claim of self-defense, and it's an avenue the prosecution is absolutely desperate to have available because through the entirety of this trial to date, there has literally been zero substantive evidence presented that is inconsistent with that claim of self-defense in a case where the state must not only disprove self-defense, but do so beyond a reasonable doubt. The difficulty for the state with respect to their unicorn drone video footage left on their doorstep by the evidence fairy is that it really shows nothing discernible at all in its original form. Even when zoomed to max on the giant 4K monitor of my personal iMac, and certainly it doesn't show anything that looks demonstrably like Kyle Rittenhouse pointing his rifle at anybody. Indeed, when this was presented to Kyle on the witness stand, he flatly denied it showed anything of the sort, testifying that to him, it merely appeared to show his shoulder rise slightly, but the muzzle of the rifle still pointed towards the ground. And frankly, that's what I see too. In response, the prosecution went back to their imaging expert, James Armstrong, who had provided the evidentiary foundation for the initial admission of the drone video footage in the first place. The prosecution asked James to clarify and magnify, enlarge, the tiny area of the video footage that purportedly showed Kyle pointing the rifle. And here's where the difficulty arises. In the magnification, digital images consist of a number of pixels of different color, which collectively form a mosaic image we recognize as a photo or video. In our modern IT world, for example, many common images for internet use are 1920 pixels wide and 1080 pixels high. The infamous 1920 by 1080. Imagine now that you want to take a small portion of that 1920 by 1080 image, perhaps a segment that's only a tenth those dimensions, 192 by 108, and magnify it substantially so that the small selected portion ends up being 1920 by 1080, the same size as the original. Well, you started with 1/10 of the pixels of the original, and you want to get back to, well, 10/10, that number of pixels. So what do? What in fact happens is that whatever imaging software is used to do this zoom or enlargement will spread out the 10th of the pixels until they occupy the area of the 1920 by 1080 footprint of the original, and then fill in the empty space between the original pixels with brand new pixels. But pixels have color, and these brand new pixels don't inherently come with any color. They are newborn pixels. So what to do? Well, most imaging software will guess at what color the new pixel should be by looking at the actual color of one of its adjacent original pixels. Is the neighboring original pixel blue? Well, maybe the software makes the new pixel blue. Now, clearly, this is new information being added to the enlarged version of the image, this new blue pixel that was not contained in the original image. Other imaging software doesn't just assume the color of the nearest adjacent original pixel, but may look at multiple nearby pixels. And this creates its own problems for the task of ensuring that the enlarged image faithfully reflects the original image. For example, imagine an original image that consists of solely an alternating pattern of red and blue pixels. You enlarge it tenfold, then you dump in a bunch of newborn pixels without color yet, and now those pixels need to be assigned some color. The imaging software might assign some of them the color red, and others the color blue, and still others the color purple, a combination of red and blue, but a color that never actually existed in the original. That purple pixel is now a false artifact in the enlargement that is not a fair and accurate representation of the original image. In normal life, of course, we don't enlarge our own photos by tenfold, or at least we don't do it more than once. Such a sizable increase tends to result in a blobby image with indistinct borders and colors, more resembling a complex visual stew than an accurate depiction of whatever the original image might have been. That, however, is essentially what the prosecution has done in this case. They have taken a very small portion of a distant image taken by the drone camera, the portion that purportedly shows Kyle Rittenhouse pointing his rifle at Joshua Ziminski, and then enlarged that image enormously until it appeared to show what the prosecution wanted it to show. The difficulty here is that what is now being shown in this substantially enlarged image may consist largely of artifacts introduced by the imaging software algorithm when it added pixels and then applied some black box method to assigning colors to those pixels. This is the defense objection to the state's offer of these quote-unquote enhanced images from the drone video, without which images the state has essentially nothing to offer to counter Kyle's claim of self-defense, and therefore this objection and the prosecution's struggle to overcome it became the pivotal battle of the day around state imaging expert James Armstrong. There were, of course, other witnesses, including the defense use of force expert Dr. John Black, police officer Brittany Bray, and Drew Hernandez, a professional commentator. But with the exception of Dr. Black's contribution to the arguments over the state's enhanced photos, none of that really mattered all that much. So let's dive into the unicorn enhanced images left by the evidence fairy debate. One of the humorous aspects of the offer of these enhanced images was watching both parties pretending that there wasn't going to be a fight over them, even though everyone, or at least I certainly knew, there definitely was going to be a fight over them. Prior to the last court break that preceded the state offering these images, the state assured the court that they didn't expect any big argument over these, and the defense just shrugged, keeping its cards close to the chest. Well, not really. Just prior to state expert James Armstrong being recalled to the stand to offer these enhanced images of his, the defense expert, Dr. John Black, found himself back on the witness stand in the afternoon after having his morning testimony interrupted due to an unexpected series of circumstances. At this point, the defense clearly knew the Armstrong enhanced images testimony was coming shortly. So they had Dr. Black explain to the jury the whole added pixels of algorithm selected color issue in his own testimony. Therefore, when it came time for the state to offer Armstrong's testimony in support of the admission of his quote-unquote enhanced images, the defense had laid the groundwork with Judge Schroeder to first voir dire Armstrong outside of the presence of the jury and before he would testify in front of the jury about the images. And that's where we get into the meat of things with respect to these enhanced images. Now, because it was the defense challenging the state's offer of evidence, it was the defense in the person of attorney Corey Chirafisi who led the direct on the voir dire of Armstrong. During that voir dire, he essentially covered the explanation of image enlargement, adding newly born pixels of a color determined by a black box algorithm in much the same way I've described it for all of you. The point, of course, is that to the extent that this enhancement process may insert newly created artifacts in creating the enlarged version of the enlarged version may no longer be a fair and accurate representation of the original. And if that's the case, it's not admissible as evidence in its own right. The party offering the enhanced version would have to settle for simply showing the jury the original. Of course, if the original had been adequate to their purpose, they would not have bothered to make the enhanced version in the first place. So they are, as a result, left with an original which does not serve their purpose. That's their dilemma. The bottom line for this defense voir dire of Armstrong was that he conceded that the enlargement of the image required the placement of new pixels, that those pixels were necessarily assigned a color, that it was the software algorithm that selected the particular color, and that he personally had no idea how the algorithm made that choice and so could not inform the court of how that was done. Now, the video of that testimony, like the video of all the testimony I referenced today in this content, is included in the text version of that content. The state's own voir dire of Armstrong after the defense had finished was led by Assistant DA Jim Krause. It didn't directly counter the defense position. How could it, when the defense position had just been affirmed by the state's image expert Armstrong himself? Instead, the prosecution engaged in the kind of frantic hand-waving we've come to expect from them. Isn't this software you used a gold standard for forensic image analysis? Armstrong confirmed it was, but that doesn't change his own admission that the software inserts pixels that are colored by a process he can't explain. Wasn't your work peer-reviewed by another qualified forensic image analyst? It was, but again, that doesn't change the added pixels with computer-assigned colors problem. Isn't your forensic lab accredited? It sure is, but again, that has nothing to do with the algorithm concern the defense had raised. Really, all the prosecution can do is engage in appeals to authority, but not in a manner that addressed the core issues and concerns raised by the defense. In short, while Krause got Armstrong to affirm repeatedly that really this is how he and many others use the software all the time, at no point could Armstrong be knocked from the unavoidable concession that the algorithm added new pixels not in the original and assigned those pixels colors in a way he himself did not understand. And indeed, the state voir dire of Armstrong was mercifully short because it was unavoidably superficial. Then Judge Schroeder decided to take a look for himself. So we had the parties argue the matter to Judge Schroeder, the defense arguing they shouldn't come in because we couldn't affirm that they were fair and accurate representations of the original. The defense offered a motion to have these sketchy as heck enhanced images be deemed inadmissible as evidence. In response to the reasoned arguments of the defense, Assistant DA Krause responded primarily with large quantities of desperation and flop sweat. At this point, Judge Schroeder asked to take a look at the images himself. And when he looked these over at the bench, he clearly couldn't make much out of them. So he then asked to be shown the drone video footage from where the images had been captured, which he watched standing before a giant 4K television from a few inches distant. Here followed a humorous sequence of events in which the judge watched the relevant portion of the drone video, apparently saw nothing that was obviously useful, and said again, and then again, and again, and once more. I suggest to all of you that if these enhanced images in the video from which they were taken were as obviously decisive as the state would like to believe and would like the jury to believe, it doesn't take multiple viewings to come to that conclusion. In the end, the judge still seemed unconvinced that he'd seen what the state claimed the images and video to show, and he walked back to his bench shaking his head. Ultimately, Judge Schroeder decided that he would let the state argue its offering of the enhanced image to the jury by the direct testimony of Armstrong in front of that jury. In turn, the defense would have the opportunity to cross-examine Armstrong in front of the jury, exposing his uncertainty as to how the newly added pixels were assigned colors in the enhanced images. From there, the judge figured the jury could make its own determination about how much weight to assign to these enhanced images. So now we had the direct questioning of James Armstrong by the state in front of the jury, questioning their expert to elicit the testimony needed to provide the foundation required for the enhanced images to be offered into evidence. This was now again being done in front of the jury, which had been brought back into the courtroom. Again, this was largely duplicative of the arguments I've already described, so I'm not going to go over them again in detail. This was followed by defense attorney Corey Tarafasi, who conducted the cross-examination of Armstrong. And again, he was largely repeating the same lines of argument I've already covered that were made on voir dire. Then, obviously fearful that Judge Schroeder might yet decide the enhanced photo images might fail to qualify for admission as evidence, Assistant DA Krause returned on redirect with more argument and repeated a common error of this prosecution throughout the trial of asking a witness a question to which he didn't know the answer and to which he got an answer he would not like. At about 1 minute 35 seconds into this redirect, Krause asked Armstrong, "So you do compare the enhanced image to the original?" And shockingly, Armstrong responded, I did not compare the enhanced image to the original in this instance. No. Amazing. I believe at that point I live commented something to the effect of WTF? Now, Tarafasi naturally jumped on this surprising concession on re-cross-examination of Armstrong. Effectively, he asked, wait a minute, you're offering this enhanced version of the images as being fair and accurate representations of the originals, but you don't actually bother to compare them side by side with the original? Nope. So then we got a redirect by James Armstrong, I should say, by Assistant DA Krause in a final reflection of how desperate the state is to get these enhanced images into evidence and before the jury. Assistant DA Krause actually came back for this redirect of Armstrong in an ultimately successful effort to rehabilitate the witness enough to keep the door open for the admission of the enhanced images into evidence. And ultimately, the judge allowed these enhanced images to be published to the jury, meaning the jury actually got to see them for the first time. Importantly, Armstrong was never permitted to characterize the images. He was never permitted to recite the state's characterization that the images showed Kyle Rittenhouse pointing his rifle at Joshua Ziminski. That characterization will be left to the state to pursue during its closing arguments to the jury on Monday. In any case, this enhanced image testimony would ultimately prove to be the last evidence to be offered in this trial, after which both sides rested, concluding the evidentiary portion of the Kyle Rittenhouse trial. Now, immediately following, the parties and the judge had a discussion outside the hearing of the jury about the schedule moving forward, so I'll share that with you. Tomorrow morning, the court will return to session to finalize the jury instructions to be given to the jury prior to their deliberations. Actually, I believe they'll be given the instructions prior to opening argument, so they'll hear opening argument in the context of those instructions. Most of these instructions will simply be the standardized jury instructions for each of the criminal charges, including all the lesser included offenses for the intentional homicide and attempted intentional homicide charges. With respect to the troublesome gun possession charge, count 6 in the criminal complaint, the judge has asked the parties to each submit their own proposed jury instructions, and I expect that argument over that particular issue will consume the bulk of the court's time tomorrow. That said, the court is not returning to session in the morning until 10 a.m. Central Time, and I would not expect the proceedings to take more than 2 or 3 hours, including the reasonably anticipated tiresome tirades over the gun possession instructions likely to be indulged in by Assistant DA Thomas blah, blah, blah Binger. What about the other witnesses of the day? Well, the most notable was Dr. John Black, the defense use of force expert, and frankly, his only real contribution was to make clear that contrary to the state's suggestions, Kyle had been compelled to make his use of force decisions in time periods measured in seconds. The state had been using various rhetorical ruses to suggest that Kyle had the luxury of all the time in the world before casually deciding to shoot, maim, and recklessly endanger a bunch of people. In pretrial hearings, Judge Schroeder had ruled that Black would be permitted to testify to technical matters like timing of events and gunshots, but not to the apparent intent of the actors involved in the night's events, nor would he be permitted to pronounce legal conclusions. For example, Kyle's conduct clearly qualifies as lawful self-defense. That's for the jury to decide. So essentially, the technical stuff, the timing, was what Dr. Black was limited to in his actual testimony. So it was, useful for the defense, but far from dramatic. Also, as already mentioned, Dr. Black proved helpful in preparing the foundation for the defense attack on the testimony of James Armstrong and ensuring that the defense was equipped to expose the fragility of the state's enhanced images to the jury. We also heard from Kenosha Police Officer Brittany Bray. She had done evidence collection at Sheridan Road, where Kyle had shot at Jump Kick Man and missed, shot at Anthony Huber and hit with fatal results, and shot at Gage Grosskreutz, vaporizing his bicep. The state had suggested at one point Kyle had been required to cycle his AR-15 pattern rifle due to a malfunction, which would show, I suppose, a certain deliberation in his shooting of Grosskreutz. And frankly, I don't really see what it matters, but in any case, the defense didn't like this representation. So the defense position is that if Kyle had cycled his weapon, a live .223 round would have been injected onto the road, and Officer Bray had found no live .223 round. Now, this is, of course, a mistaken understanding of such things. If there had been, for example, a failure to feed malfunction, that could require cycling of the action, but with the chamber empty, and there would have been no live round to eject. The state would point this out in its own cross-examination of Bray by Assistant DA Binger, after which the defense, on redirect, would have Bray assist them in measuring the 4 inches required to cycle the charging handle on the AR, meaning the movement would have been obvious on video had it occurred, and it certainly is not obvious. And that was pretty much it for Bray. That brings us to the only other witness of the day, which is one Drew Hernandez, another one of those folks who apparently wanders around riot scenes filming for social media. The most notable facet of Hernandez's testimony was his clear contempt for Assistant DA Binger and his apparent implicit, perhaps explicit, support for Kyle Rittenhouse, despite his protestations of not being biased. Hernandez certainly struck me as biased in favor of the defense and against the state, and it would have probably served his purpose to have toned down the hate towards the state a bit. He did say many positive things about Kyle, including describing how Kyle was helping people and de-escalating conflict, and he also said many negative things about Joseph Rosenbaum, including seeing him be provocative, combative, setting fires. But his obvious bias in favor of the defense meant that whatever he said wasn't likely to change anybody's mind. If you already favored Kyle, you nodded your head at the apparent truth of Hernandez's testimony. If you already favored the state, you discounted the Hernandez testimony entirely on the basis of his obvious bias. So that's where we stand at the close of court business today. So join us again tomorrow morning for our live coverage of the trial of Kyle Rittenhouse at legalinsurrection.com. Keep in mind, it may be a much shortened day as it doesn't begin until 10 a.m. Central Time, and even then involves no testimony, but only argument over the jury instructions. If the day went much longer than 4 hours, I'd be rather surprised. Until then, remember, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, then you also owe it to yourself to make sure you know the law, so you're hard to convict. Until tomorrow morning, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.